We are very lucky that in order to have some of these conversations, we have with us today Susan Griffith, who is the Executive Director of the Timpanogos Legal Center and Professor of Law at the Brigham Young University Law School. The Timpanogos Legal Center is a nonprofit organization that works with local attorneys to provide pro bono services to low-income people and victims of abuse. And we all love free services, right? And it's a wonderful organization that Susan was actually a part of founding. She's also been teaching at BYU since 1995 and is the director of the Family Law Clinic and the Domestic Violence Intervention Clinic. She's also worked as the Assistant Attorney General in Child Protection. So Susan is an immense wealth of information after 30 years of working to help victims of intimate partner violence navigate the legal system. So Susan, thank you for being here to speak with us today.
Thank you. I'm very happy to be here to talk about the legal system, and you're exactly right, it's very confusing for victims, especially when you recognize that they can be involved in criminal proceedings, family law proceedings, protective order proceedings, and even with the juvenile court. And they're all separate and have different standards, and it becomes very complicated.
Speaking of complicated, in the course of this video, we'll be answering many different questions about different parts of the legal system. Please know that you can pause the video at any time, and there will also be the opportunity to explore individual questions on the website at a later time. It might be helpful for you to have something to take notes. Now might even be a great time to pause the video and grab something if you don't already have it with you. We'd also like to make a couple notes of our own. We want to note that victims of intimate partner violence can be men, women, or other gender minorities. So we may use pronouns interchangeably, but many victims are women. In addition to that, we want to note that this video is not intended to substitute legal counsel or to speak to your specific case individually. Susan has some thoughts about how that might work in a really complicated system.
It is, and we understand that this website is going to be used by people all over the world, and obviously there's going to be big differences between countries, but even here in the United States, the laws vary tremendously from state to state, and even from city to city. We call it a jurisdiction, the area the area that a court can rule over. And people need to be familiar with the way the laws work in their area, and even though there will be differences between judges in the same area. And that's why it's so important to talk to an attorney from your local area who can give you very specific advice and counsel about how to handle your issues.
So as we're getting ready to dive into the real meat here, I'd say that as a clinician, oftentimes what I'm working with clients in is parts of the criminal process and criminal proceedings that are particularly scary. It's an intimidating process. So in this section of questions, we're going to be addressing the basics of criminal issues, from police involvement and courts to the resources that might be available to you as a survivor of domestic violence. I'll ask some of these questions in the way that it's posed to me by my clients as they're coming in. One of the first things that I might hear is, the police were called to my home to investigate domestic violence. What is going to happen now?
The police may have already arrested the abuser or cited that person with a crime, or they may continue their investigation. The information would then be referred to the prosecutor's office, and the prosecutor is the one who will ultimately make the decision about what charges would be filed against the abuser.
So it sounds like the prosecutor will determine what charges come forward. Thinking as a victim, what is my role in the criminal proceedings against the abuser?
A lot of times the victims feel like they're the ones that have to press charges, and that is not the case. It's going to come from a prosecutor's office. The role of the victim is actually as a witness in this case.
So it sounds like they'll make the decision. Is it possible that I won't have to serve as a witness?
Most cases are settled, the vast majority of them, without a trial, and so very often the victim doesn't have to testify at all.
So it sounds like if there is a criminal process, it's possible that I could be called as a witness. Do I have a choice as to whether or not I serve as a witness?
You really don't. If the prosecutor subpoenas you to appear at the trial, you are obligated to appear in court. Now, you do have the option to contact the prosecutor's office and let the prosecutor know how you feel about it, and more importantly, why you either don't want to appear or why you're concerned. It might be about your safety if you were to appear. The prosecutor should know what your fears are and what your concerns are. And often in the United States, you can go through a victim advocate that will work with the prosecutor. So you don't necessarily have to call the specific prosecutor, but you can get that information to the person through your victim advocate.
So I can make my wishes known, but it's not ultimately my decision. Can I tell the prosecutor that I want to drop the case altogether?
You can tell the prosecutor that, but the prosecutor is not obligated to follow your wishes. The prosecutor is representing the protection of the community. It's not just about the case that happened in your home. It was a crime. And so the prosecutor has a broader picture, although prosecutors try to be sensitive to the needs of the victims and to do what's going to help them. They have more considerations that they also take into account.
And we want to acknowledge how frustrating that can be when it feels like this is something that's personally affecting you and so much of it is outside of your control. But having information about what is in your control and what's not is helpful as you're moving through the process. Now, thinking about the fact that I won't have the choice of whether I testify or whether or not the case is brought into court, something that I often hear clients ask is, I'm afraid of my abuser and afraid to testify. What can I do to stay safe during the court process?
That's a very real issue. And so it might be necessary to actually go into a shelter or to go to an undisclosed location, a friend or someone that your partner would not know or guess where you would be located. Also, you can obtain a protective order, and we will talk more about protective orders later in this discussion.
And we really want to emphasize, victims are the experts in their situation. I tell my clients over and over again, you are the best person to know how safe you are and what steps you need to take if that's going to a shelter or moving location to keep yourself safe. And it's always a good idea to kind of let your prosecutor know why you're afraid if that's coming up for you in some of these proceedings. But that's all if these charges are brought to light. I also have plenty of clients come forward and say, charges have never been filed against my abuser. When is it too late for me to do that?
Often when charges haven't been filed, it's because police have never been called. There's never been an investigation. And so I get the same kinds of questions. And what I tell people is you always have the right to report it. So you can go down to the police department where the abuse occurred and just say, this happened a long time ago, but I want to make a report about what happened. And they will give you the opportunity to fill out a report on what it was that happened and when. Now, it will be up to that individual department in terms of how they will investigate it, or even if they will investigate it, if it's been a long time. But everybody has the right to be able to file a report.
So it sounds like I can go in and make a statement about what happened at any time, but the police might not do anything with that information. So what are the reasons why a person might want to file a police report on past abuse?
The foremost reason is because you want to create a record that abuse has been happening during the course of the relationship. That's particularly important if the abuse is increasing or intensifying. But the other reason is that we have a really wonderful program in the United States called Crime Victims Reparations. We abbreviate it CVR for short. And it's basically a fund of money that's available for victims for needs like therapy, for changing locks, for putting locks on windows, things like that that give safety to victims or the opportunity for healing. But in order to be eligible for those funds, you have to show that you're willing to cooperate with law enforcement and prosecution. And so by filing that police report, it makes you eligible for that, even if the police don't follow through with an investigation.
So it sounds like there are real benefits to filing a police report here in the United States specifically, but I often hear from my clients a lot of fear. And so will my abuser know that I filed a report?
And that's probably the biggest reason why victims often don't report it, is out of that fear. If the police investigate it, probably the first place that they're going to go is to the alleged perpetrator to get that side of the story. And even if they don't disclose, where the complaint came from, the abuser is going to assume that it was from the victim. And so the victim should be concerned about that and can perhaps ask the police to notify them if they do intend to go and question the perpetrator.
So that's helpful. I can ask to be notified before they question them. And again, relying on that intelligence and your knowledge of your relationship to know if you should go to a shelter or an undisclosed location for your own safety.
Absolutely.
We're talking about a lot of things that might not necessarily be specific to an individual person, and we're really encouraging folks to follow up with their local resources. So along that line, who can answer my questions about criminal proceedings and what to expect in court?
In most locations throughout the United States, we have what's called victim advocates. And victim advocates are such a powerful tool for people who've been in abusive relationships. They aren't attorneys, they don't represent the person in court, but they can accompany the person when they go to court proceedings. And that provides such an important service, in that it can be very intimidating, the thought of going into a court building and friends and family of the perpetrator might be there, and having someone that can get you into a secure room where you're not having to be out there with them. The victim advocate can also provide many services like referrals to other things: housing, utility assistance, food assistance, getting help in finding a job, just a whole list of different therapists, groups that are available. So many different referrals that are really important. And then additionally, they often will help give the person who's been abused either the forms to fill out in order to obtain a protective order, or in some cases, the victim advocate may even help them fill out the documents that are necessary for that.
So there's a long list of things here that victim advocates are doing to assist survivors of domestic violence. What should I do if there's not a victim advocate?
Well, first of all, you can call the national hotline, which number is going to appear on the screen, and they can tell you if there is a victim advocate in your area. So you don't have to try and find where your victim advocate is. One number will tell you if there is a victim advocate that's available. And if not, you can go directly to your prosecutor's office and talk to the prosecutor or a representative from their office about what the next steps are, what your role will be, what you need to be aware of, those kinds of things.
Sounds like the prosecutor has a very involved role. So if we're thinking about the prosecutor, who does the prosecutor represent?
The prosecutor represents the city or the district or the state where the crime occurred. The prosecutor does not represent the victim, although most prosecutors are trained to be sensitive to the needs of the victim. But because the crime was committed against, it happened within the community, and that's what the prosecutor's primary concern is about. And so the victim has the right to tell the prosecutor and give input about what they want to have happen, but the prosecutor might be looking at broader things that are involved in that case and may not go with what the victim wants to have happen in that case.
So the prosecutor is really looking out for community safety. And in light of that, I think I often get questions from clients that are like, why would a prosecutor dismiss some of the charges against the perpetrator and not hold them accountable for everything?
That can feel so frustrating to victims, especially when they've been in long-term abusive relationships, and finally it feels like, there's going to be some accountability, and then they see prosecutors dismissing charges and it feels like, they don't understand how serious the situation has been. And let me just explain that that's not what's happening. The criminal justice system in general relies on prosecutors making plea deals with perpetrators in all different kinds of cases. This is true. Most cases don't go to trial. Most cases are settled because they are able to arrange a plea deal. So prosecutors, when they initially get the information from the police, will charge as many possible offenses as they can, in order that they know that they can then dismiss some of those and still get a sentence that is going to be significant for the crime that's been committed.
And again, we want to acknowledge how personally distressing that can be. It may be that the charge that was dropped is the one that was most personally meaningful to you. We want to create sensitivity around how painful these things can be, but do want you to be informed about what the process can look like, and hopefully understanding the reasoning why behind some of these decisions are being made will be helpful in terms of just processing the experience generally.
And I'll just add that prosecutors usually look at it in terms of the things that they dismiss are the things that are going to have the least impact on the total sentence. So it may be the charge that felt most personally significant to the victim, but the prosecutor's looking at it in terms of what is the best sentence that I can get in this particular case.
Now, in addition to having clients who are concerned about their abusers being held accountable, there are also clients who are really worried about how it might affect the perpetrator to go through this process. So, will the criminal process destroy my partner's ability to work and get credit if he gets convicted?
That's such an important question for victims, because a lot of victims, it's not necessarily that they wanted the perpetrator to get arrested, they wanted the violence to stop. And so now they're concerned the violence stopped, but what are the ramifications going to be for the whole family? And so it is, if the perpetrator is convicted, that conviction is going to show on their record, which can affect everything from credit ratings to the ability to get housing, to the ability to get a job or keep their job. And so it can have big consequences.
So thinking of that, is there a way to hold my abuser accountable without wrecking their ability to pass a background check?
Very often the victim wants the abuser to be held accountable, but hasn't necessarily decided to leave the relationship and doesn't want to have the entire family impacted by the consequences of this. The answer is that having a conviction does show up on background checks and even credit reports, and so it can influence everything from the ability to get a job or keep a job or credit rating or the ability to get housing, and those are significant things. Knowing that, the criminal justice system has looked at a way to try and prevent especially first-time offenders from having those serious consequences. In Utah, we call it a plea in abeyance. It might be called something different in another jurisdiction, but the concept is that the perpetrator takes responsibility for what happened. They admit that the crimes happened, and then there is an agreement with the prosecutor on what terms must be fulfilled, and usually it includes having an assessment, getting treatment, having no further instances of abuse, no other criminal charges. Those are some of the common things. There might be others depending on what's involved in this situation. If after the specified period of time, the person who's been charged completes all of those requirements, then that plea has been fulfilled and the charge will not show up on their credit report or on their background check. Now, it doesn't completely go away. The FBI can still see it and the prosecutor's office can still see it, so that if there's charges again, they don't get the same opportunity to have that, or at least many times they don't. But it is a way that the perpetrator can still be held accountable without having really catastrophic impact for the entire family. The ability to, even if they do separate, if the person can't pay child support or pay debts that were incurred during the course of the relationship, those can be really negative consequences for the victim and the family.
I also know, as we're thinking about criminal proceedings, I'll have many clients who are coming to me and saying, I've been abused throughout the relationship, But when I defended myself and I left marks on my partner, the police arrested me. So we've been talking a lot about the perpetrator in the criminal system, but what about the victim? If I have charges pending against me, how can I find an attorney to defend me?
In most jurisdictions, you have to be at risk of jail time in order to get a free public defender. And if it's a misdemeanor case and it's a first charge, it's very unlikely that would happen. And so there's a good chance you wouldn't be given a free attorney. So that leaves you with two choices. You either have to hire an attorney, which everyone knows is expensive, or you represent yourself.
If I have to represent myself in criminal charges, what do I need to know?
You should be aware that you will have an opportunity at a pretrial. So before you go to that final trial, you'll have an opportunity to talk to the prosecutor. And at that time, that's usually when they talk about what kind of plea agreement you might enter into. And so it's important to know about that plea in abeyance, or whatever it's called in your jurisdiction, because you can talk to your prosecutor about whether that might be the right kind of an answer for your situation. You need to be very careful in talking to the prosecutor, because you need to be aware anything that you tell the prosecutor also can be used against you. On the other hand, you want the prosecutor to understand the story, and especially if you feel like the police didn't get it right in their report. They didn't identify past abuse that had happened, or they didn't understand that the scratch marks that were made were in an effort to free yourself to get out the door. You know, those kinds of things that frequently happen. If the police didn't give that description, you give that description to the prosecutor and help the prosecutor understand your version of the facts that might help the prosecutor have a better sense of what was going on in that case and what the appropriate consequence should be. But don't forget, they're not your friend. They're the prosecutor, and so you have to be very careful about how that conversation goes.
So being sure to share as much detail as is useful to kind of get them aware of the situation, to make it known that you're the primary victim of abuse, while not potentially sharing information that could be held against you as you go through the proceedings.
Right.
You know, thinking again of the abuser, I often find that victims will say, my abuser is making many promises to me that if I refuse to testify or I don't show up in court, they'll do something, go get treatment, or stop the abuse. How should I handle those kinds of requests?
This might be one of the first times the perpetrator's ever been put in a position where they are going to be held accountable, and there could be consequences for the bad things that have happened during this relationship. And so very often the perpetrator will make all the promises you've ever wanted to hear. I will stop drinking, I'll get a different job, I'll go into counseling, whatever it is that has been requested before. They're probably going to be promising it now in an effort to make this bad thing for them go away. My experience over and over and over again is, as soon as that case is dismissed, it goes right back to the same things that have been happening in the past. And here's the thing that I would want a person who's been abused to know and understand, and that is, we understand why the person who's been abused can be very compassionate with it. This is a person they've sometimes had children with, they've had often a long-term relationship with. It's a person they really care about. And so they don't want bad things to happen to that person, but they do want the abuse to stop.
Yeah.
And the problem is that the promises that were made to the person who's been abused can't be enforced by anyone except the court. So by keeping that order there, if the perpetrator doesn't do the things right, then there's a consequence. If the case is dismissed and doesn't do the things, there's no consequence for that.
So important things to kind of keep in mind is there's not the guarantee that your partner's behavior will change. But based on some of our previous conversations, there is a guarantee that because you're a subpoenaed witness, you are at risk of being held legally responsible for not showing up. We really want to weigh those things carefully as you're making a decision. And thinking about all of the things that can occur in the course of intimate partner violence, sometimes I'll hear the question, how is something like strangulation different from other violent acts, particularly in how that's seen by the legal system, and what is important for me to report?
It is so important to report anything where there's been pressure applied to the throat or to the breathing. It can happen in a multitude of different ways. But the reason for that is the consequences of that action are life endangering. It can create severe disability, if not death. And for that reason, prosecutors often charge that offense as a felony instead of as a misdemeanor assault. And so it's important for the victim to understand how to report that to the police. Because sometimes in the past, victims would just report it as, he choked me, which is not the right word. Choking is something that gets lodged in your throat, not a force that comes externally, which is strangulation.
And I think from a psychological perspective, to kind of add to why that's treated with such severity, we know that even just a few minutes of oxygen deprivation to the brain can lead to death. And kind of the severity of its impact on the brain will vary based on a number of factors. But based on the length of time and the severity of the oxygen deprivation, folks might experience a type of brain injury known as an anoxic or hypoxic brain injury. And here's kind of why that matters. Folks who have those kinds of injuries might end up with problems that are long-lasting that can affect things like thinking skills, motor skills, and even psychological functioning. We know that if it affects consciousness, so if there's a lack of consciousness, it's more likely that that's going to have a negative impact on the brain. And I find that it can be hard to know sometimes whether or not you've lost consciousness. So thinking about some clues that there might be, remembering waking up, but not the things preceding that. So loss of memory doesn't mean that there was a loss of consciousness, because sometimes trauma can affect memory, or the result of a brain injury can be a loss of memory. But it's an important clue that you might want to share with a doctor. So if you can remember waking up somewhere without much memory of incidents before, or a loss of memory generally about an incident, that could be an important clue if you can't directly remember losing consciousness. If we're thinking about other really important things that you want to be sure to describe to your doctor, make sure you describe in detail any event where you've had your breath obstructed. So that could mean smothered by a pillow, having your head submerged underwater, having hands or any other kind of object placed around your neck. Really, anything that's designed to restrict your breathing, you're going to want to make sure to mention to a doctor. And here are some things that might be important to detail. How many times have these events happened to you? It's likely that it's been more than once. How long did each of those events last, if you can remember? Did you lose consciousness? Again, keeping in mind some of those clues of what that can look like. And what were the mechanisms of how you were injured? So again, that's just the simple details of, was it the pillow? Was it hands around the neck? Describing the way that that obstruction to your breath occurred would be really important to share. Also keep in mind that there's a very strong fight or flight reflex that can occur when something is vital to your survival as breath is being threatened. So what we know is that there can be very strong psychological effects that occur for you. That might be something like trauma and PTSD symptoms that you start to notice. So paying attention to how this can influence you and making sure to bring that all to your doctor's attention. And also, more importantly, to have some compassion with yourself throughout this process. Those symptoms can be difficult to navigate and manage, whether it's increased fear of the world around you, difficulty with memory, hypervigilance and startling. Have some compassion with yourself, and know that it's okay to turn to resources to get assistance as you're navigating having those symptoms.
Those things that you just described, Ariel, are so important. And we want people who've been through that to go to a doctor because they need to get the treatment and they need to be assessed because of the possible damages. It's very important to get that report in the hands of the prosecutor as well. And what we see often, the victim, at the time the police come, if you've just recovered, you've kind of blacked out for whatever reason, you can't remember what's happened, it's very hard to articulate to the police what just happened. And so it may be after the police have left, it may be days later that you're thinking, I might have blacked out. You may not have recognized it at the time. Go get that medical treatment, talk with your doctor about that, and then get that report to the prosecutor, because the way that you described it to the police, it may not be clear that that's what happened to you, yet the prosecutor really needs that information.
As a follow-up question to that, if the police have gotten things potentially incorrect in their report, I go to a doctor and I've gotten additional information about what's occurred and potential injuries that I've sustained, and I feel that that's not accurately documented in a police report, would it be appropriate for me to go and file an additional police report to capture some of the things I experienced?
Usually you'll have the name of a police officer and you can say, I went and had a physical after this and the doctor has a report I want to share with you. And they will be happy to take that information and make it part of the file.
Great. So you don't need a new police report, just contact the officer and ensure that he has that information. And make sure the prosecutor is aware of that information in the case of the court.
Right.
All right. So criminal proceedings are certainly something that take a lot of time and attention and are concerning, but it's not the only thing that I think victims are worried about when it comes to the courts. Often, divorce and custody issues are really prominent at the top of their mind. In the process of divorce, and particularly when you're concerned about custody for your children, you can develop some barriers to leaving an abusive relationship. Absolutely. But knowledge and information are really powerful resources to making some of those decisions. So in this next set of questions, we're going to be exploring what to do before separation, how to find the right attorney, and important topics that you might want to consider along the way. So again, thinking from the perspective of the victim, I'm thinking about separating. Are there certain things that I should do?
First of all, it's really important to have copies of all of your important papers, and it's much easier to get things like former tax filings, bank statements, information about your mortgage or home ownership, all of those kinds of things while you're still in the house and all of the records are available to you. It's much harder if you've had to sort of flee the situation and you don't have any of those records available.
Would it be helpful to bring in an attorney at this point in the process, or should I be waiting?
No, it's a good idea to talk to an attorney, get advice. You don't have to commit that you are getting divorced or that you're going to need to seek custody if there wasn't a marriage. Getting information right up front about how the process works in your area, your jurisdiction, is a very good idea. And there's usually going to be specific laws for the place where you live. In some places they have automatic injunctions that stop people from terminating phone service or selling or disposing of assets or things like that. In other places they don't. You have to seek them. So you need to know some of those things so you know what to expect, what you can do, and what the other side might be thinking about doing. And you need to be prepared with that information.
So it sounds like injunctions are specific court orders that can prevent actions, but it varies by location. So it's a good idea to get an attorney in my area involved as soon as possible so that I know what could potentially happen.
That's right.
And thinking of finding attorneys, why is it to my advantage to call the free legal service programs in my area as soon as possible?
You know, one of the things that we've seen abusers do is when they get the sense that things might be coming to an end, attorneys have ethical rules that prohibit, if I've talked to one party, I can't represent the other party. And so abusers will frequently go make a contact, not really even having the intent, knowing that they're not going to qualify for the services, but they just make the contact so that their name is in the system first, which then prevents the victim from accessing those services.
So even if they haven't represented them, if they've even spoken to them on the phone, they can no longer provide those free services to me.
I've even seen situations in small areas where the opposing party will contact every attorney in that area, so that the victim then has to get someone from outside of that area, and that increases their attorney's fees because of the transportation costs and things like that.
So it doesn't have to be a commitment that you'll follow through, but it's important to at least contact some of these free legal services so that they remain an option for you if you do decide to follow through. It's not a commitment, but it's just securing your options.
Right.
So I understand that it's very expensive and difficult to change attorneys. So the most important thing that I can do is make the right decision about the attorney at the outset. What is the best process for finding a good attorney?
That is such a difficult question, because how do you find the right attorney? And it's so unique person to person. I often compare it to therapists. Not every therapist is the perfect one. It's very individual. So here's some things that you can do. First of all, talk to friends and family. Everyone knows someone who's been divorced. Talk to people, find out their recommendations if they know some really good attorneys in your area. Second, go to Google and do some checking on the attorneys. You'll start to see names that will resurface as being good. Then go to their websites, read about them. Where did they go to school? What's their area of expertise? See what things stand out to you as, oh, this is looking good to me, but don't end there. After that, you want to come up with a list of probably 3 or 4 attorneys that you feel like have kind of are at the top. And one of the things that sounds very expensive to do, but I really recommend you at least interview 2 or 3 of them. Now, some attorneys will do a free consult, but most of them won't. Or some of them will do reduced cost consults. But it's worth the time to make sure that you're getting the right attorney for you. It's an investment, because if you have to change attorneys, it is so expensive. So you want to make sure you're getting the right person from the outset.
Is there anything you should watch out for with attorneys in those interviews? Any red flags that might indicate they're not the one for you?
Oh, I think there's a lot of things. It starts with asking the right questions. If you ask the attorney, and there's a whole list of different kinds of questions that you could ask. I would ask, what percentage of your cases are like mine? You want to know that family law isn't just kind of an area they do to the side. And very specifically, you don't have a standard family law case. You have a case that has domestic violence issues in them. Ask them how many times they've handled those kinds of cases. Ask the attorney, what do they consider a good result in a divorce case? Because that's when there's no win or loss. Everybody feels like they lose in divorce. And so get the attorney's perspective on what they see as a win. Ask them what their philosophy is in handling a contested divorce case. Most divorce cases settle. Domestic violence cases are harder to settle. And so the case is likely to be contested. Find out what your attorney's theory is on handling those cases, what their strategies are when they're handling those kinds of situations. What is their approach going to be in mediation when they know that they're going to be hitting up against a brick wall abuser type of personality? Ask the attorney, what do you think is the likely outcome of my case? And see if the attorney is trying to promise you the world or if they're going to tell you the truth. Yeah. You want someone who's going to tell you the truth. There's a lot of attorneys who will promise the world because they want your retainer. They want you to put the money down, and then they quickly, they're the ones who don't call you back. They tell you, oh, you should just go ahead and settle for this, and you're wondering, well, where's my fighter at, right? So ask the questions to really kind of try and boil down, what is this attorney really going to do? Ask the attorney what they're going to do to keep you informed of what's the status of the case. The number one complaint filed with the bar in family law cases is failure to return phone calls. So find out, how frequently are you going to be in communication with me? If I can't get a hold of you, is there a legal assistant assistant that I can talk to. Find out about billing. Do you bill the legal assistant for a different amount than you bill out your own time? How often will I get statements that itemize what it is that you're billing me for? Get into the specifics of some of those details so you know exactly what to expect. And if the attorney is kind of hum-haing about those things, that gives you a pretty clear picture of what you're going to be dealing with.
So in addition to that, is it possible for me to speak with other clients? Is that an appropriate thing to ask?
You can ask the attorney for that. Now there is, because of attorney-client confidentiality,
Sure.
Attorneys can't just tell you, oh, I handled this case and this case and this case. But sometimes attorneys will ask some of their former clients if they can have permission to allow a prospective client to contact them and get information. So some attorneys will have that and some won't.
Are there other ways to check up on them, like looking at articles or bar websites?
Yes, you can always check with your bar website to make sure the attorney is in good standing. And you can do the Google search to look and see if there's been any press releases or news articles relating to your attorney.
What questions should I ask in order to find the best family law attorney, specifically with experience in domestic violence cases?
That really is important because a lot of attorneys will say, oh yes, I do have experience, and it means that they've represented maybe a couple of people in a protective order hearing, but they don't really know the hardcore dynamics of what's been going on in the abuse case. And it really is helpful if your attorney is prepared for those issues, particularly because we know abusers often bring in parental alienation and some other things we're going to also be talking about. If your attorney isn't prepared to handle with those issues, it can be really, really difficult. So I would ask some very specific questions, and don't let the attorney give an answer that says, well, I would do this. You're asking these questions saying, when you've handled domestic violence cases, how have you handled this issue? And some examples of issues that you might want to bring up. You will be familiar with what you think is going to come up in your case, so you might have some of your own ideas, but here's some examples. What do you do to refute allegations that the victim's been an inadequate parent? That's very often the case, right? How did you handle a situation where the abuser underreported income and they own the business, and so you're not getting any information on the finances? That happens very often in abuse cases. They're very controlling of the finances. Records are hard to come by or don't exist. How did they deal with that? And get an answer for how they actually dealt with a real case of that. Ask how they handle it when the abuser asked for full custody of the children, even though the abused person is the one who had primarily been the one taking care of the kids during the relationship. How did they actually handle that issue?
And just as a note, you'll have the opportunity to pause the screen, write down the questions as they're popping up. We'll also have them housed on the website if you want to come back to these questions. There's a lot of information here, so try not to feel too overwhelmed. It's okay to notice if that's coming up for you, but just as a quick reminder, these will be options available for you so that you'll be able to keep these notes and come back to them as often as you need to have them as a reference point.
And I just add, write down your questions that you want to ask the attorney that you will talk to as well.
Absolutely. And in thinking about some of the other things that you've mentioned, some of the potential contentions that come up in these kinds of divorce cases, I'll have clients ask, I have a history of mental health problems and or substance use. How concerned should I be about that becoming part of the case and being used against me when it comes to custody of my kids?
I think sometimes that's one of the issues that keeps a person who's been abused in the relationship because they feel like they're going to be blamed for everything that's gone wrong in the relationship. And that definitely is a tactic that's used by abusers. And the other thing that we have to confront is that often the person who's been abused has turned to substances either as a way to cope or an escape mechanism from the horrible reality that they've been dealing with. And so that really, in my opinion, isn't something to be embarrassed or ashamed about. It's something to deal with head on. And I found that in 30 years of working with victims, the victims that are willing to actually confront those issues head on do a lot better. There's a tendency to want to like downplay, oh, that didn't really happen, or oh, and usually that becomes more problematic if there really have been those issues during the relationship. You should expect that the abuser is going to try and make a big deal out of it. That's just the reality of it. But that doesn't mean that the abuser is going to win because of that. What I found is that when you have a person who's been abused, who does take on those issues directly, you get into counseling, you get into treatment, you get into support groups, you build a new support structure around yourself that truly is healthy. It allows the person to get to stability. There's good news and bad news about being in the court system. The bad news is it takes a long time to get through the court system, especially on a contested case. The good news is that helps a person who has some issues that need to be worked through. You don't have to appear before the judge immediately when everything's going sideways. You have some time to get some of these things in order and in a good place, so that by the time, if you do have to go to trial, by the time you get to trial, you say, yeah, there were a lot of problems at the time that we finally separated. But let's look at what's happened for me, and let's look at what's happened for the abuser. Because typically the victim just really, once they get out from under that abuse, it's really hard, but they start doing a lot better. And a lot of times for the abuser, they start spinning more wildly when they can't control. And the judge gets to see that too. And so that's very explainable. A capable attorney can handle those difficult kinds of issues. But if you resist getting into treatment, resist the things that are going to lead to long-term stability, that makes it harder to get through some of those issues.
And I think something that can come up really frequently is a feeling of shame around some of these things. And so if there's anything that we can do, even in just saying, it is very normal and human to have those reactions. Human beings, when put in traumatic, difficult circumstances, will often experience things like depression and anxiety. They'll struggle with their mental health or use substances as a way to cope with something that's really impossible to wrap your mind around. It's not alone. You're not alone in having that experience, and you're certainly not alone in figuring out ways to move forward. You have an attorney who can help you to kind of strategize and work through what's going to happen, and there are often local resources that are available for free. If you're interested in receiving therapy, counseling, and working to develop a support system with other survivors of domestic violence, those services are going to be available for you locally. And again, the National Domestic Violence Hotline is a great resource to pursue. They'll help to connect you to some of those things that are available so that you can build that support system over time.
One of the things that makes me the most sad in dealing with people who have been abused is the feeling that they often have of their failures, that they're less than other people because of that. And sometimes they blame themselves. Why did I stay in this situation for so long, or how did I get here? And it feels impossible to get out of that situation. And what I tell my clients is that anyone who had been in the reality of their situation would have been confronted with exactly the same things. And the feeling of weakness that they're experiencing at that time is not accurate. They're actually incredibly strong, that they've lived through everything that they've lived through, and that now they can harness that strength that they've built up during that time that doesn't feel like strength, but it took a lot to get through what they have, and they can take that strength now and build for themselves a place of stability and a place of hope and a place of something so much better that they can't even see right now during that time of crisis when they're making that decision to leave.
Right. And then thinking of those who are really seeking resources to build on that for themselves and for the better, I'll have clients who say, I have been experiencing some signs and symptoms of brain injury that I suspect is from the abuse I experienced. And that could be things like difficulty with memory, difficulty with language, sensitivity to light, and headaches that are coming up for them. So if someone's experiencing some of those things and worried about potential brain injury, Could that be used against me in my custody case?
I know that is such a complex situation for the person who's been abused, because on one hand, you want the prosecutor to have that diagnosis. You want to get the diagnosis so that that can be handled in the criminal system. But those very same people who get that diagnosis are then like, well, then is that going to be used against me that I have a brain injury in my custody case? So it helps me in my prosecution, but it hurts me in my family law case. And that's a difficult situation to be in. Every person has to kind of make that decision for themselves as far as what they want to do, but I would do that in consultation with your attorney, because the reality of it is, if your doctor can help you get treatment that can help you function in a way where your children are going to be safe and your children are going to be healthy, then there's no reason why that should impact your parenting plan. But if there are physical limitations that would make it very difficult to parent, for example, young children who are dependent on you, it could have an impact on what the court decides.
And I think an important first step in that process is really getting an assessment. And if we're thinking about what's the assessment process like, from a psychological perspective, what we're looking to do in that kind of assessment is really figure out what are some of your cognitive strengths and weaknesses. So you might be noticing things like, I'm having a hard time planning and organizing, I'm having a hard time remembering, I'm getting frequent headaches, and those things are interfering with my ability to function. What we're going to do is we're going to come in, get an idea of what things are functioning well for you and what things are a difficulty, and then you'll have a treatment team that's going to specialize some specific recommendations that will help you to build on the strengths that you have and address some of the weaknesses. And of course, your abuser might use that against you in a court of law, but you can minimize that risk. So if you can come in and demonstrate to the courts that you've implemented the recommendations and you've done it in a timely manner and consistently. So as soon as possible and over again across time, you're going to be in a much better position to say, I'm recognizing what's happening for me, and here are the things that I'm doing to make sure that I'm addressing it appropriately. It could be something like a neuropsychological assessment, where they're going to be looking at thinking skills, mood, and behavior, or a psychological assessment, and or neurorehabilitation. So that could be things like speech therapy or physical therapy or other things to just help you build back to a place where you've got some skills you can use to compensate for some of those difficulties that you're experiencing. So we call those your compensatory strategies. And if you're really working to include those in a plan and having your attorney looped into what you're doing, it can minimize the risk that will be used against you in court.
That's right. And it's also creating the opportunity for you to have people that can testify in your behalf, saying this person is following all treatment recommendations. They're working hard and have gained, stability or been able to compensate in the following ways that makes them suitable for having regular parent time or being the primary custodial parent, whatever the situation is.
Oftentimes I have clients who know others who have been through this process or a similar process, and they might come to me and say, I know someone who was also married to an abusive person, and the abuser turned everything around and made it look like the abused parent was alienating the children from having a good relationship with the abuser. How do I protect myself against that?
It is difficult. That is a challenge, and it's a very frequent argument that's made by abusive parents. And the way that it's set up, it goes like this. During the course of the relationship, the abused parent is the one who became the buffer between the abuser and the children. The abused parent would arrange things literally when they could feel the tension mounting. Get the children, go play at the neighbor's house. Why don't you go down to the basement? And literally put themselves between the abuser and the children. And in that way, the children were always safe from abuse. They weren't abused by the abuser during the course of the relationship. Well, now that there's a separation, and since that abusive parent never harmed the children, that parent's going to get unsupervised parent time. And that can be really scary for the parent who's been protective of the children. And it's not uncommon for that abusive parent to then, when the parent is being very vigilant about making sure that the children are safe when they go, the abusive parent will say, oh, they're saying things to the kids about I might abuse them, and we try and safety plan with the children of if something happened, where would you go, who would you call, what would you try to do so that the child is prepared. Well, going through those steps of preparing the children can be argued to be you're alienating the children, you're planting in their minds that I'm going to abuse them. So it's very important for the parent who has been the protector to make sure that when you are safety planning with the children, you do it in a very calculated way. And usually it's better to not come from the parent. This is where it's better to have the child go see their own therapist and have the therapist do that kind of safety planning so that it's not coming from the parent, and that will help reduce the risk of those allegations.
How can I keep my children safe during visitation or other times with the abuser?
One of the things that can really help is to make it a condition that's written into the parenting plan that says the child is allowed to have a phone and is allowed to call the other parent during parent time. Now, sometimes there's arguments then over some parents use access to the phone as a privilege or as a punishment. And so we've had cases where the parent has taken the phone away so that the child couldn't call the parent. So you want to do things like make sure that your child does have the ability to know how to dial a phone number, which a lot of us don't know phone numbers anymore because we're so used to having them on our cell phone. If the child doesn't have access to the hit the name, would the child be able to call from a landline? Do they know the phone number? When you're dealing with very young children, of course, that the phone isn't going to help. But in many cases, that can be an additional layer of protection for the child. You know that the child could reach out to you if there was a concern.
And many therapists are trained to work with children who have experienced domestic violence at home. They'll be able to work with your kiddo to create a safety plan and to figure out some ways so that it's not coming from you, because we do have to be careful if it seems like one parent is making the child afraid to spend time with another parent. You run into the risk of being accused of parental alienation. So work with your therapist who will be well trained to make sure that your kiddo has a good safety plan and can enact those plans if necessary.
And they also can teach the child that without making it sound like a scary situation.
Absolutely. Now, thinking of protection, we're going to shift gears a little bit here and move into a new section of questions. Because if we're thinking about protection, one thing that often comes up for folks is protective orders. You might have heard of a protective order or be in the process of trying to get one yourself already. And this section is really going to address what a protection order is, what it provides, and what its limitations are. So if we're thinking of that, let's start with the very basics for us here. What is a protective order and how does it work?
Okay, well, first of all, in every jurisdiction, there's different names. In your area, it might be called a restraining order. In some places, a restraining order is actually different than a protective order. So you need to find out what is in your area. And usually you can do that with a Google search. But we're going to use the generic term protective order. So the protective order can include everything from the stay away from the home, stay away from the petitioner, the person who requested the protective order, stay away from the children in some cases if there's facts to support that. You can also have provisions in there of don't harm, harass, threaten, intimidate, annoy. It also includes the no contact orders where you have to stay away through email, text, social media, through other people. So there's a lot of different provisions that the judge can sign off on in the protective order, and affords protection to the person who's requested this order. You now have something that if the person comes to the home of the petitioner, even though that person has no intent to cause any harm, they might be in the stage of domestic violence where it's like, I'm coming to promise you all of the good things and I want to get back together again. And there's absolutely no intent to harm. It's all about, I want to get back together again. Well, the fact that they're there is the crime. There doesn't have to be a new criminal act in order to get enforcement. And that's the real power of protective orders, is it helps prevent getting into the situation where there will be new instances of violence.
So it sounds like what a protective order includes can vary by what's requested and by state. Who can I go to figure out the process of a protective order and how it might specifically apply to my situation?
That will once again depend on your area. You can probably do a Google search to find out a lot of the basics, but most people can go to the courthouse and the court clerks can either tell you where to locate forms to do it, or so much of it's done online now, of course, and would be available just with that simple Google search. The other place is if you can get a hold of that victim advocate, and once again, we have that number posted to find out if there's a victim advocate in your area. Victim advocates are always trained on where are the forms for protective orders, how do you access it. Often they can answer a lot of the questions about the services that are available. In some places, there are free services that will help you actually fill out the petitions. Sometimes there's even free legal representation for you at the protective orders. It will just depend on what services are available in your area.
Is this something an attorney can help me with if I have one?
Yes, absolutely. You may, if you've decided to proceed with divorce or a custody case, you might want that same attorney to represent you in the protective order proceeding as well. In other cases, you might be able to get a free attorney to represent you in that part, and then you would retain the attorney for your divorce or custody case.
So in thinking of getting a protective order, what are some of the advantages that come with getting one?
The primary advantage is that when the order is issued, in most states it's put on a statewide system. That means when dispatch is notified of a new call, a new problem, they can tell the officer that's en route to the scene that there is a protective order in place. And so the officer gets to the site knowing that they have the authority to arrest. That prevents a situation where if it's a first-time call, officers go in, they're going to talk to everybody about what happened, investigate the whole thing before determining whether there's going to be an arrest or citation. With a protective order, it's clear who's going to be arrested. So that's an important protection. Another thing is that inside of that order, it's usually a specific section on where the respondent in the protective order, or the abuser, where the places that person has to stay away. And typically it's from the home of the petitioner, the workplace of the petitioner, other places maybe that person frequents. Those things might be listed in the order. So it's a clear, where can the abuser not go, or it's a violation of the protective order. There's a provision that there should be no contact by any other means. So that would include by text, by email, through the use of others like family members or friends making contact with the person. So it gives the space for the person who's been abused to not be getting a lot of pressure through those other means of contact, where the person can't physically hurt them through an email, but can apply that emotional pressure. And so it gives that kind of free space to the person who's been abused. And that's a very important part of the protective order process. The fact that the protective order exists is a protection to the victim, and they know that violation of that can result in arrest. And so it gives the opportunity for the person who's been the victim to maybe be able to stay in their own home and not feel like they have to leave in order to be safe. And then the protective order creates a record that abuse has happened. And that can be important in those cases, especially where there's intensifying or increasing abuse that's happening. And another important feature that most people don't immediately recognize is that there's also federal laws that prohibit people who have protective orders entered against them from carrying firearms. And so that can be an important provision for the person who's experienced abuse as well. Now, there's in some places, and it will depend on your state, but there are, in some protective orders, they'll also take care of what's called the civil portion. So the parts that we've been talking about, there's criminal enforcement. There can be arrests or citations for violations of those parts. There can also be these civil provisions where it takes care of things like who gets to stay in the home during this period of time, who gets possession of the car or the cars, how is child custody going to be arranged, when, who gets to see the children and when, and how will drop-offs and pickup happen so that the parties aren't coming in contact with each other. How is support going to work? Who's going to financially take care of the children during this period of time? Those are some of the civil things. You can't get arrests for violations of those things, but now you have an order that spells out how it's going to work during this period of time. And that takes away a lot of the uncertainty, which is such a difficult component of abuse relationships. And so that becomes a very big benefit for the person who's been abused.
I think many victims are looking to feel safe, and I'll often get the question, will a protective order really keep me safe?
That is a really good question. The protective order works if the police can arrive before the bad thing happens. And that's the issue. I'm often asked, are protective orders really effective? And the answer is yes. If you have time to get the police there, they're very effective. But if you have a person who's bent on killing or seriously harming the person, and there isn't time between when that event starts and the ability to call the police, then a protective order is a piece of paper. And we need to recognize the benefits that the protective order gives, which are many,
right, but
there's also very real limitations. And so if there is fear that the person really could, it's at that level where the person really needs to not stay in the home. They need to get into a shelter that's at an undisclosed location or some other place so that they truly can be safe.
What should I do if my abuser gets a protective order against me?
Those are frustrating situations, and that's where you really do have to talk to an attorney in your local area to find out what the policies and procedures are. In most cases, it's going to be possible to counter petition. So at the time that you're notified that a petition has been filed against you, you can counter with, here's my side of the story and what's been happening. And this is why there shouldn't be a protective order entered in this case, but there should be a protective order entered in my behalf instead. And then that becomes a factual issue for the court to decide, right? There's going to be a hearing where both sides are going to put on their evidence, and the court's going to make a decision about whether no protective order is entered, or whether it's entered on behalf of one person, or whether there's going to be a mutual protective order, which they try to make that rare because it's difficult to enforce those. But those are the options.
If I get a background check and I have a protective order against me, will that show up?
Yes, yes.
How do I find out how to terminate a protective order in my state?
Once again, talking to an attorney or a victim advocate about how that process works in your state is important. One of the things to know is that, so when you talked about the background check, it's a lot of times you can explain to the person who's requesting the background check why there's a protective order in place, but it's very difficult to explain if there's been a violation of a protective order. The fact the protective order exists that may not cause an automatic bar to getting housing or to getting a job. But if you violated a protective order, that's going to be very hard to explain. So just make sure if that protective order does get entered against you, comply with it, even if it doesn't seem fair.
And if I comply with the conditions, is it possible for it to get dismissed?
Usually there's a set period of time that the protective order will last in your state. And so that's the first thing to check out. The second thing to check out is if there is a way to contest the protective order that has been entered. Most protective orders start out as what we call ex parte orders, meaning they're temporary. They were given with just one side's notice to the court, and so the court wants to hear what the other side of the story is before making that final order. And so you have that opportunity to go to court, make the explanation, counter it if you are in need of the protective order, and hopefully get the right result at the end of that hearing.
If there's a protective order in place, am I still allowed to contact my abuser about things like parenting and paying bills?
That becomes very complicated because it is, and once again, as I've said often, it depends on the rules in your state, but most of the time, the police get really upset when the protective order is entered against one person and then the other person makes contact. It makes it seem like, are you really in fear if now that you've got this order, you're making contact with the person you're saying has been abusing you? And so even if you're not going to, there aren't consequences for you, it doesn't put you in a favorable light with the people that you want to have enforce that order. So the best thing to do is to work through attorneys. Your attorney can talk to the other side's attorney, but there aren't always attorneys on both sides. And so then you have to look at other options. And a lot of times the best way is to put the instructions right in the order as far as what will happen. How will communication happen in order to do a parent exchange? And sometimes it's worked out by the one parent appoints a person to be the contact point, and the other parent picks another person, and those two people communicate with each other in order to make the arrangements work.
So it sounds like there's maybe times that you need to contact the person, and doing it through writing is going to be a good way to make sure that it's kind of documented, and really to be careful and know that abusers will often try to use any exception to a no contact order as a way to speak to you about other things. So keeping some of those warnings in mind and having the ability to communicate through written expression is a safe way to go about it.
That's right. And there's even new apps now that are meant exactly for custody cases, and it tracks every communication, and that can go straight to the court. And so those apps are a nice substitute when you allow an exception to communicate by text for the purpose of parent time only. Very often those texts become about more than just the parent exchange. There will be something about that and then a bunch of other things that aren't pleasant and aren't appropriate. So it's nicer to have it in that separate app that tracks everything, knowing that that can go before a judge.
In thinking of a protective order, why does a protective order provide my abuser with my address and vehicle information?
That's a challenging question for victims, and it often seems inconsistent that they would request that. So in most cases, what will happen is the victim can apply for the protective order without disclosing, for example, if they've moved to a new apartment or a new home. They don't have to disclose that on the protective order. It will say address protected. Then there's a separate form that the victim fills out that is submitted to the court that does have the address, because the court needs to be able to contact them and know where they're at. The problem becomes when that address is not known to dispatch, then they can't tie the protective order to the protected address. And sometimes that becomes a disadvantage for the victim. So that's why having addresses can be helpful, is that it makes it known to the police which addresses are protected, but sometimes the advantage of that isn't as big as the disadvantage of having the perpetrator know what those addresses are.
And it's often the case that in this process, victims are having to make complicated decisions that weigh the pros and cons, and the only way to do that for your specific circumstance is to know the possible options.
Right.
It would be great if there was only pros and a clear right or wrong answer, but it is important for victims to really learn to trust themselves. You can trust your instincts. Work with your therapist, work with your attorney, work with other folks in your support system, but trust yourself to make the right decision using all of the information you have to kind of weigh those pros and cons.
And along with those people that you talked about, the victim advocates are
Yes.
also really good about explaining how things work locally and in their experience, what typically works out best for victims in similar situations.
So in addition to some of these more specific instances and cases, there are questions that come up about the broad legal process and things that might apply generally to court proceedings. So in this next section, we'll kind of explore some of the general legal questions related to the process of separating from your abuser, questions that you might need to know about your attorney, confidentiality, and some of these other catch-all kinds of questions. So to start, what do I need to know about how attorneys bill?
That's really important. If you are retaining an attorney, you don't want to get surprised by what you're agreeing to. So when you go in for that initial consultation where you're deciding if you are hiring them, and that's another thing I would say is that a lot of times people going in see the attorney as the person in power, and so they defer to them. Really, you're the person who's making the controlling decision. You're deciding whether to hire that person. So don't fear asking questions. And one of the primary questions should be, how is the billing going to work? First of all, it helps to know how attorneys work in general. They bill by the hour, and those amounts vary greatly, a lot of times depending on the place that you're in. But you need to make sure you understand what that hourly rate is. And understanding, it sounds so exorbitant, but that hourly rate covers the rental of their building, all of their supplies, the payment of their support staffs and the IT people and all of the things that go behind it. So it seems like, oh, my attorney is making so much per hour, but it's really carrying a lot of those costs. You want to understand the attorney is going to ask you for a retainer, which means a certain amount of money up front, and then the attorney is going to bill against that amount. So it's usually thousands of dollars that they ask you for. You want to know what the amount that they're asking for is based on. So for example, usually they'll feel like the case probably will end in a mediation, a resolution. So is this amount only good through the mediation? And if there's trial, then there'll be another retainer after that. Will it include doing temporary orders, or is it assuming that's not going to happen? You want to know what is built in to the price that they are quoting you, so you have an expectation of how long that money will last. You want to ask the attorney things like, how do you bill out your support staff? Is that at a lower hourly rate than your rate? How often will you get the bill? Will it be itemized? Some of those important questions. And if you and then make sure when you get the billing statement that you're reading it, that it makes sense. And just know it takes a lot more time than you would expect to do even simple things.
It seems like this whole process takes almost learning a new language. And some of it is just getting familiar with what those terms mean and how they apply. So one thing I might hear is, who can I speak to confidentially?
Most people know that attorneys owe a duty of confidentiality to their clients. That means they're not going to go talk about you to other attorneys or to other people. But that also extends to the office staff of the attorney, their employees. The attorney has the right to discuss your case with people within their office because you have retained them as part of their office. But it shouldn't go outside of that office.
So they're going to be confidential. You'll work with that attorney, but you've talked about it being a thing of fit. And what do I do if I'm not happy with my attorney?
That happens a lot because attorneys who do family law work deal with a high volume of clients. And that means they're dealing with the most pressing issue at the moment. And you're always feeling like your issues are pressing in the moment, but they may not be the highest priority that the attorney has right at that time. So the first thing is try and work things out with your attorney. Probably don't just keep calling and leaving a million messages. Try and talk to a support staff person if you're not getting through and say, hey, I've been trying to get a hold of this person. I've been doing it through email. Is there a better way? Or I've been leaving voice messages. Should I do something else? The support staff can often tell you, oh, they're in a trial, or give the reason for it. You want to be nice to the support staff. Don't start yelling at them, because those are the people that can actually get your message to the attorney. If they feel like you're becoming a problem, that's not going to make it easier for you to get the results that you want. So first, work with the attorney. Second, try and work with the support staff. If you still haven't gotten anywhere with that, then you have several options. And those options include, one, filing a bar complaint. And in most places, that's as easy as, once again, getting online, look up the bar association in your area and how to file a complaint. You say what's been happening, and then they will have someone from their Office of Professional Conduct do an investigation. Now, the thing you need to understand about that is that doesn't change the outcome of your case. The judge isn't notified, oh, this has been filed, so now everything else is on hold. You still have to meet all of the same filings and the hearings coming up and all of that, and filing a bar complaint does not change that. But it usually gets the attorney's attention, and maybe that's what you need. The second thing that you can do is, if you feel like it's actually negatively impacted you, you've lost a hearing because the attorney wasn't prepared or didn't show up or something like that, there are attorneys that specialize in suing other attorneys, and you might file a malpractice action. Now, once again, that doesn't get you custody of your children. It gives you a dollar amount for the harm that you suffered. And most people are like, that doesn't help me. What I care about is protecting my children. So your final option is to fire that attorney and hire a different attorney. But you need to know that's going to be very expensive for you. It costs a lot more to hire that second attorney, because that attorney then has to go back through everything that's happened before. It takes a lot of time to review all of that. You're going to get billed for that. And a lot of times they want to go file new things to help fix whatever they feel like was wrong. That's going to cost more money too. So if there's any way to repair the relationship with the attorney, you want to start with that, because of how expensive it is to switch over. On the other hand, if things are really going south, you don't want to wait too long either. If you are going to have to hire a new attorney, sooner is better than later, because you don't want to be getting orders that are disadvantaging you during the process.
It is such a complex and involved process, and something that I think I hear often is, why are there so many court hearings? There are multiple court hearings.
For people that are involved in abusive relationships, you could have a criminal case, a family law divorce or custody case, a protective order case, and if whatever your version of social services, Division of Child and Family Services, gets involved in the case and does an investigation because the kids were present when the abuse took place, you might have juvenile court proceedings as well. Those are 4 very distinct court systems that are all going to be a part of your life. And the reason it's so frustrating is that each one of those 4 types of cases have different, what we call elements. Those are the things that have to be proved inside of them. They're different in all 4 of those. There are different people involved. In some cases, in some of those proceedings, there's a guardian ad litem, but not in others. In some of them, there's a prosecutor, not in others. In some of them, so you get the point. And a lot of times I talk to victims who are like, well, my victim advocate told me this is how it worked. And that's true for the criminal case that the victim advocate is part of, but not true in the juvenile court part or in the family law part where the victim advocate isn't involved. So sometimes people are given information by professionals that are involved and they think it applies to all of their situations when it only applies to the one particular part that that person's connected to. Very, very difficult for the average person to try and understand, how am I supposed to keep each of these things separate and understand what a court is capable of ordering. Courts are actually limited. They can't just order anything they want. They can only order what they have jurisdiction over. And a lot of times when you've got 4 different kinds of proceedings happening, it's not possible to really understand all, which one is the right place to go to ask for what you need.
And I think that's when it becomes really important to stay organized and rely on your resources to be really clear. So to keep everything for each different case in a separate place so that you can try and keep them apart. But understanding that it's because it's 4 different courts and 4 different cases is helpful. It's not all involved, and it's important to keep an eye out for when it's changed from one case to another.
Yes, and ask questions. That is, I think sometimes people are reluctant to ask questions. They don't know exactly how to word the questions, and so it's easier to stay silent. Give yourself permission to ask awkward questions, but keep asking the questions until you get the answers and you get clarity on how this is working. You have the right to understand the process that you're involved in. And so ask the people, whether it's your attorney or the prosecutor or a social services worker if you're involved in the juvenile court, keep asking questions until you understand. It's fair for you to get to understand those processes.
Thinking of that, there's so much time that's invested into all of this. And occasionally I'll have a client say, I'm worried about losing my job if I have to take time off to go to court. How likely is that?
Well, and you can imagine, especially when you've got 4 different potential cases going on, just how many times. And then often nothing's more frustrated. You take the afternoon off of work to go appear at the hearing and you find out it was continued and no one told you. And so now you not only miss that day, but you're going to have to miss another day for when it really does happen. And often people who've been abused get caught up in that very challenging circumstance. And so one of the things you want to do is, first of all, if you're planning on attending a hearing, always confirm with either the prosecutor's office or your attorneys that you really do have the right date and time and that there haven't been any continuances. And then tell your employer. Now, your employer doesn't have to know all of the details of what's going on in your case, but sometimes it does make your employer a little more sympathetic about why you're asking for so much time off, if they do understand at least some of the fundamentals of what it is that you're dealing with. That's a personal decision about what you feel comfortable in conveying to the employer. Now, in some places, there are provisions. There are victims' rights in virtually every state, and you can look at if there's any protections inside of those statutes or inside of your, sometimes it's a constitutional amendment to have victims' rights. And so, for example, in my jurisdiction, there's a statutory allowance for a professional, so a prosecutor or a victim advocate, someone like that, to call the employer on your behalf and say, this person is needed at this hearing, and this is why, and so we would really appreciate your cooperation in allowing the person the time off to do that. Now, they can't force the employer to do that, but they can encourage the person. And sometimes the employer is more willing to hear it from a prosecutor than they are from their worker on the line, right? That's asking for yet more time off.
In thinking of that, is there anything that I can do to pursue reparations or anything that can happen to help me financially with the cost of time off work?
There are, because it does come at a cost, right? You either have to take vacation time that now you can't use for vacation, or you maybe are taking time off without pay. and that costs you. There's a real cost to that for the victim. So if it's in a side of a criminal case, the victim does have the right to tell the prosecutor, look, I have missed X number of hours from work. This is my rate of pay. I want to request reparations, we call it, for that money that I lost because of being involved in this system. And the prosecutor can request that that money be part of the sentence when the person is eventually convicted. Now, sometimes that takes a long time to get to that judgment. And then if the person's put in prison for a period of time in a more serious case, obviously they're not earning any money to pay you back. And so even though you can get the judgment, it doesn't always put dollars in your pocket. And that's one of the things that can be difficult for victims is you can ask for it, you probably will be awarded it, or there's a good chance of that, but it doesn't necessarily mean that the money's actually going to be coming to you very quickly.
Which is an important thing to consider.
Yes.
Something that might be worth pursuing, but you don't want to be dependent on that money coming in a short period.
You don't want to have unrealistic expectations about
Right.
what that means.
So we've talked a lot about some of the more broad, general issues that can occur. Now we're going to transition to something that's a little bit more specific, and that's going to be looking precisely at brain injury. So we know that it's common for victims of domestic violence to have head injuries. That can be from blows to the face, head, or neck, or strangulation. And this section really covers things to consider when it comes to medical treatment, to managing symptoms, and navigating the court system and processes when dealing with brain injury. And we're going to do a little bit of a change up because I hear that you actually have some questions that you've come across in your work that we might be able to provide some information from a psychological perspective and how that could be helpful for your client.
Yes, we'll do a little role reversal now because your area of expertise is on the impact of brain injuries, and it's really important for our viewers to understand just how these brain injuries can impact their court case as well. So to start out with, brain injuries often cause, as we've talked about before, headaches. It makes it hard to focus, difficult to concentrate. Bright lights can make it even worse. What is someone in that situation to do?
I think it's really important to remember headaches are a really common and persistent problem, and that doesn't make anything immediately better, but it's helpful to know that you're not alone in having some of those difficulties. So if you've had a concussion or some other type of brain injury, a headache is a really common symptom that can persist afterwards. And here's something that's really important is that those kinds of post-concussive headaches really can make it hard for you to participate in court activities. And there are things that can be done to be helpful. An important reminder is that you're going to need the appropriate documentation in order for you to get any accommodations from the court formally. So that's the first thing, is we want to make sure that you're getting proper medical documentation of what's going on. We've talked about that a little bit with some of the assessments that you can pursue. Use your victim advocate. Use your support system. Be incredibly honest with the folks who are around you about what's happening and how that's affecting your ability to focus or concentrate or participate, so that they know exactly what they can do to be helpful, whether or not that's taking notes, helping you to schedule items in your phone during the court case, whatever it might be. Having a support system or a victim advocate who can help you with whatever you've identified as hard during that process. And just know that you don't have to be embarrassed. Everyone needs help, but particularly in really complex situations like this, it's normal to be relying on multiple people to help you stay organized and keep up with what's going on.
I wish that, I've had so many clients in the past that I wish had this information, because so often they present as, I don't remember things, this is really hard for me, with no explanation as to why. And when you don't have an understanding for why this is happening, the system is a lot less responsive to those needs. And so I love that, identifying when you have that potential issue so that you can get the help and support you need. People will be much more receptive to trying to help him deal with those issues when that's happened.
That makes a lot of sense. And I think it can be difficult to recognize what some of those symptoms are if you haven't come across them before. So if you find that following your abusive relationship and those abusive episodes, you're noticing that you're having difficulty organizing and planning, difficulty with memory, difficulty with language, headaches, all of those are good indicators that there's something going on there, and it might be helpful for an assessment to figure out what's happening and how you can be supported.
Yes. And you know, this has been great information for me too, because we need to train attorneys to ask these questions, you know, and I think that would make a big difference too. Well, you know, it's interesting that at this very time that we're talking about, here's the person who's potentially coming into the legal system who has memory problems, has a difficulty focusing, and now we're asking them to track this incredible amount of information as they're going through the court system. How on earth are they supposed to keep track of all of this?
And that's another good part about having other folks who have experienced the same thing, is we've had the opportunity to develop some tips and recommendations that have worked for other people who have experienced similar things following a traumatic brain injury. So here are some helpful recommendations for people who are having trouble keeping track of information, especially if there's been a brain injury as the result of abuse. 1, try to reduce your distractions that could come up when you're hearing information that you need to remember, and then be sure to write down whatever helpful information is being shared. So if, for instance, you know you're going to have an important conversation with someone and you've got kiddos around, seeing if there is a support person who can watch children for you so that there's not the interruptions and the asking that can happen. Try not to have important meetings in public locations or areas that are loud or distracting. Try to go somewhere where you'll be able to focus. And even in that kind of circumstance, make sure that you've got a pen and a paper and that you're ready to write things down. And hopefully you'll keep all of that in the same location with the other information so it stays together. You don't write it down and then it gets lost somewhere. Try to keep it all together in one location. Another thing is, and I think you've emphasized this before, but do not be afraid to ask somebody to repeat themselves or clarify what you've just heard. I'm sure that you can say the same for you, but I am always thrilled when someone asks me a question, because that just means that what I'm trying to show you will be more useful. That means that I have the opportunity to make sure you can actually use the information that I'm trying to share with you. So never hesitate to ask a question if you're unsure about what's being said or unclear about how that might be relevant to you in your case. So be sure to ask and write those things down. It's really helpful to set reminders for things like meetings and appointments and even to-do tasks. And that can be something that works well for you. You might have a reminder system in your cell phone. There might be a physical planner or organizer that you utilize, but do be sure to keep track of it and do it in a way that's going to be helpful. I personally need the alarm to go off and remind me of something that's going to be happening, right? Some folks might need it to say an hour before it's going to start, I need an alarm to go off and remind me that this is happening, but have kind of a concise place that you can do that. It's also helpful to have a place where you're storing all of the relevant information and one location so that you know where to go back to and where it's going to be housed. Maybe you've got a table by your front door and you can keep a binder there with everything relevant to your court cases. And anytime you take notes, you add it directly to that binder, or a counter or a desktop. Whatever works well for you, but keeping that all in the same place where you can access it conveniently, you can receive things and put it into that system easily. Another thing that's really important, we can get hard on ourselves. Like, I'm frustrated that I can't do this. It's a big, overwhelming task. But what we know about big, overwhelming tasks is that if you can break it down into smaller chunks, taking the very next step feels much more manageable, right? If we're talking about tackling the legal court system, that feels incredibly scary. But if we can talk about calling the National Domestic Violence Hotline to see if I can find a victim advocate, that step might feel doable. So break things down into very small tasks and check them off as you're kind of completing them and getting them done. That's going to make it much easier to make sure that you're staying on top of all of the things that need to happen and making sure that it doesn't feel too overwhelming for you in the moment. Additionally, as you're doing that, and if you're scheduling out what you've got to get done within a day, please be sure to schedule in breaks. The brain can use that time to rest and recuperate, and what we do know is that if you're having difficulty with organization and memory, taking frequent breaks can help your brain recuperate those resources so that you'll be able to engage with the next task with a little bit more energy and a little bit more cognitive strength when you're coming back into it. So don't feel ashamed. That's a very healthy, normal way to approach it. Break things into small tasks and then make sure you schedule regular and frequent breaks in there. And the last thing that I really want to kind of emphasize is don't be afraid to rely on your support system, whether that's a victim advocate, whether that's family or friends who are going to help you organize and coordinate, from things like taking care of kiddos to writing notes for you to helping you manage your calendar. You can have things set up for other folks to send you a reminder. If you've got someone in your support system who is good with details and is able to do some of that planning and organizing for you, it can be mom or sister or friend or brother calling you and saying, hey, don't forget this Monday afternoon is going to be one of the court hearings. This is what time you'll need to leave, right? It's great to have reminders from other folks as well. So don't hesitate to rely on your support system. No one gets through difficult things alone, and it's important for you to know who can help and how they can help, and not to be afraid to kind of lean on those resources.
That is just excellent advice. You know, I have clients who don't have traumatic brain injury that really can use that same advice. There truly is no reason to feel any kind of shame on needing to ask for support or ask for the phone calls or ask for the reminders. I tell all of my clients, so many who don't have traumatic brain injuries or brain injuries of any kind, hey, I've given you a lot of legal information. If you need to come back to our clinic next week and hear this all over again, that makes sense. Right? We're asking people to deal with very complicated issues. And for anyone, it takes hearing it more than once. So that's not something to feel ashamed about or frustrated by. You're dealing with a lot, and it's fair to have questions and to need to hear things repeated. And I think it's so important that we give that support.
Do you have any recommendations that you make specifically to your clients about how to keep track of some of these details?
Yes, well, and somewhat similar to what you've just said, my biggest recommendation always is the 3-ring binder, have tabs. They don't realize how many documents are going to be involved when they start out their case, and so they collect a few documents here and there, and they go into different file folders, and pretty soon all of a sudden you've got this mess and you don't know which order it's in, and so it's just easy to quickly have things get out of hand. If you keep that 3-ring binder with the tabs and keep it in order, keep things dated, keep each section stapled together so that your pages don't get out of order, you'll have everything at your fingertips. This is good advice for anyone who's going through a court case because there's just so much to keep track of, but particularly for a person who is going through the effects of having a brain injury.
Yeah, and it sounds like it could be helpful if you have one page specifically dedicated to dates that you can keep at the front of that binder. Keeping track of when things are going on is a big part of navigating some of those court cases. And then also, it's helpful to keep track of who you're speaking to and what advice they're giving so that you can refer back to that over time. So making sure that you've got the contact information so that if you've got follow-up questions later, you can ask those questions then.
That's so true. You know, you get a lot of advice from victim advocates, from your attorney. You hear things from the court clerk or other people. So always write down your source when you're writing down what you were told, because sometimes you'll go back later and say, well, you told me that, and the attorney will be like, I didn't tell you that, and you don't remember where you heard it, and what you heard might be right, but the person you're talking to it's going to be disjointed. So writing down your source, the date and the time, very important. And that one page of dates, keeping in order the significant dates, having a timeline, because you never know when you're going to have to explain your case again. Your prosecutor leaves, a new prosecutor comes on. You have to rehire an attorney. Having that list of key dates just keeps things organized. So important.
Yeah, absolutely. So lots of things that you can try. And just remember to stay hopeful. There are tips and tricks that you can strategize and work with folks who are in your support system to find what works well for you.
I can imagine that for a person who has a brain injury, they, first of all, even recognizing that they potentially have a brain injury could seem really daunting. They might want to sort of, I mean, I feel like I would be in denial, like I don't want that to be the case, so maybe if I might be better off not asking about it. But realizing now with the things that we've said, how important it is to understand whether you have that brain injury or not. How can I find out for sure if that's the case? Is there some kind of evaluation or assessment that can be done to help me determine what's happened to me?
Absolutely. There's some really key, crucial next steps that can be taken. And I really relate to this idea of, I don't know if I've had a brain injury or what exactly happened. And so it's important to keep in mind brain injuries can result from being struck directly, or from strangulation, or from being pushed and hitting something with your head. So it's really important to keep in mind that there are lots of different ways that the brain can be impacted. And what you want to do is, anytime that there's an injury that's occurring after physical abuse, you want to go and get a medical evaluation as soon as possible. And you want to get it from a professional who's trained to do those kinds of assessments. So there will likely be a medical component, but you may ultimately decide that you want to do something like a neuropsychological assessment, where they're looking at your thinking skills and your mood and your behaviors. So first and foremost, though, getting a medical evaluation from a professional who's trained to observe things like traumatic brain injuries is going to be really helpful, because some forms of injury are really hard to detect. And it's really hard to trace their symptoms back to a specific injury after time has gone by. So you're going to want to go as soon as you can, and know that brain injury is really common when there's physical abuse and intimate partner violence. So it's something that you'll want to have checked out. In addition to know whether or not you have a diagnosis of a brain injury specifically, you're going to want to figure out what your level of functioning might be in different parts of your life, and how it might be impacting you as you're kind of going about living and trying to manage and negotiate all of those things. So depending on the type of injury you have, the severity, and the available resources that there are, your doctor might refer you for additional evaluations, like I was saying, those neuropsychological evaluations, or for some guided treatment. So it could be a neurological assessment, and that could be for disorders in your nervous system, which is kind of the brain and all of those things that are attached to it. It could be a neuropsychological evaluation, neurorehabilitation like speech therapy or physical therapy. They might refer you for a head CT or a brain MRI just to assess for evidence of bleeding or other injury to the physical structures in the brain. And sometimes it's difficult to know for sure whether your symptoms are associated with a brain injury or something else. Brain injury symptoms can be due or made worse by several other things that are happening in your life. For instance, trauma, right? We know that brain injury can affect things like memory, but so can trauma. And being in an abusive relationship is very traumatic. So a lot of these things might come together and look similar. And so that's why it's really important to kind of go to the right kind of professional, get a medical evaluation, and then follow up with whatever recommendations for additional evaluation or treatment that they might have. And the idea is they'll be able to give you really specific recommendations and strategies that you can use based on what you're experiencing, so that it can help you improve your functioning in any areas that they're finding weaknesses.
That's great. How do I am just picturing, if I were in this situation, I might find it difficult to even know, like, what doctor do I call to get this kind of assessment? Or if I just start with my own, doctor that I see for the flu, how do I know what to tell that person so that they know how to get me to the right place?
It's best, if you're looking for a doctor, to find one who's an advocate for specialized care for people who have a history of brain injury and PTSD. So trying to find a doctor who is specializing in those areas, in brain injury and PTSD, so that in the event you're evaluated and diagnosed with these things, you've got someone who's familiar with some of the nuance that can come with that. So while not everyone who has a history of intimate partner violence is going to meet criteria for a brain injury and PTSD, they commonly co-occur, and they should be assessed for together. And so it's important to recognize that the quality and the amount of information that your general primary care physician is going to have is going to be limited in terms of the range and scope. So some might know more, some might know less, but it will generally be less than someone who's specialized in those areas. And whether that's doing a Google search or even asking your primary care physician for a recommendation of someone who's specialized in those areas, it's best to pursue someone who's got some expertise in that specific place. Because many may not be able to give you good advice or treatment recommendations following a brain injury or concussion if they haven't specialized it. And if brain injury is involved, you're going to need a different level of specialized care. And the important thing to remember is to be really honest and open with your doctor. If you're trying to figure out what information should I even give them, just be really, really honest. Don't try to make the situation sound better or worse than it might be, because it's going to prevent them from being able to get an accurate assessment of what's going on for you. So you want proper treatment without wasting time, without wasting money, without pursuing options that aren't going to be helpful, and that's going to require really giving an honest evaluation to your doctor. So be sure to tell your doctor if you've had a hard hit to your head or any other part of the body. It's important to know that brain injury can occur even if you don't lose consciousness or you aren't knocked out, right? So you want to kind of share any injury that happens to the body. However, not every hit to the head results in a brain injury, right? So it can go in both directions. So just being honest and clear, being prepared to tell your doctor about any changes that you notice in your behavior or thinking skills thereafter. So if you notice that I'm feeling dazed or confused, if I'm repeating questions, I notice that I'm having trouble with my balance, my concentration, or my memory has been affected. Those are all really important things that you'd want to mention to your doctor, especially if those have developed immediately after the injury. So kind of keeping in mind when it occurred and when you started to notice those changes happening for you. You should also tell your doctor if there was any time when your abuser made it difficult for you to breathe. So again, some of those things that we've talked about with the anoxic or hypoxic brain injuries, where it's the obstruction of the breath. So that's the pillow, the head underwater, hands or objects around your neck. Making sure that you mention anything that happens, because it's very common for victims of domestic violence to experience those kinds of strangulation or oxygen deprivation injuries too.
So many people who have a brain injury have also suffered from post-traumatic stress disorder. And I think much more is known about PTSD than about brain injuries. So the question is, what should the client know about the difference between brain injuries and PTSD as it relates to their case?
You know, I think that's so important, and really to remind folks that there's going to be a lot of symptom overlap between a brain injury and PTSD. And you don't necessarily have to be the one who's able to parse those things apart in your own life and tell the difference between them, which is partially why it's so important to get in an expert. Because there is so much connection and nuance between those things, it's important to work with somebody who's gotten the specialty to tell them apart and to figure out how to help you if you're experiencing symptoms of either, in terms of what recommendations will be helpful for you. So there is a lot of overlap, and in addition, they can be diagnosed together. Yeah. It's possible for someone who has a brain injury to also have PTSD. So if you're having trouble remembering things, if you're noticing changes in your mood, if you're becoming startled or scared more easily, any other number of symptoms can be associated with both of those. It's important to know that what you're experiencing has been experienced by many people before you. And even though it's frustrating, there are supports that are in place. So there are treatment recommendations that can be made. There are support systems that can be used, whether at home or in the courts. Those are the kinds of things that are important to keep in mind, is that you're going to be experiencing some difficult things. And if your abuser is trying to use that against you within your court case, and trying to include those symptoms as a reason why you might not be fit to parent or to recollect the events that have occurred accurately, what you can say is, I'm receiving treatment and following medical advice and documenting your abilities. You're going to be much better prepared to kind of present your case. And you'll also have some experts who are able to speak to the way that those things might interact with things like domestic violence. So it's important to know that you are the expert in what's happening in your life, but there are folks who have some expertise in how that might relate to what other people have experienced and the different diagnoses that might lead us to think about.
I appreciate this so much. I can just tell you from, years ago, before we knew any of this, I'm positive that I worked with many people who had experienced these things, and their feeling was, I don't know what's wrong with me. And that's all they had to go with. They just thought, I'm failing, something's wrong with me, I don't know what it is. And just for people to know this is real, and that there's a medical explanation for it. Science documents it. This isn't something in their imagination, it's real. And I think that is so important. And the more that we can then also educate attorneys about this and how to use it will be such an important factor as well.
Absolutely. We have covered quite a bit of information and material today. And Susan, we really could not be more grateful for the time and the expertise that you've offered to having these conversations. And thinking about the folks that we're trying to work with, the survivors of domestic violence, we do want you to know that there are people who believe you. There are people who are working to ensure that you have access to the support and resources and information that you need. And if anything today has been overwhelming, we want to validate the reality of that experience, encourage you to be compassionate with yourself, and to remind you that you can take it just one step at a time. We've designed this entire conversation to be adjusted. You can come back to small portions of it. You can revisit information on the website. Know that you can do just the next thing that needs to get accomplished, and that there are people who are sending you our good thoughts and cheering you on. Thanks for being with us today.
Thank you.